standing is that the states somehow forfeit their ability to challenge the constitutionality of a provision of federal law because they voluntarily choose to participate.
I'm a little bit confused, and this is what I'm confused about. There's a challenge to the individual mandate.
Yes.
All right. What is the fact that the state is challenging Medicaid? How does it give the state standing to challenge an obligation that is not imposed on the state in any way?
The principal theory for state standing is the states are challenging the mandate because the mandate injures them when people are forced to enroll in Medicaid. Now, it is true they are not directly subject to the mandate, but
yeah, that's what I'm.
Okay, let me try it this way. May I finish the thought? In South Carolina versus Regan, the state was not subject to the tax at issue. The state was harmed as the issuer of the bonds, and the bondholders were the ones subject to the tax. So the state is injured not because it is the direct object of the federal tax, but because of its relationship to the regulated party as issuer bondholder.
Thank you, Mr. Katsas.
Thank you, Mr. Chief.
Mr. Long, you have 5 minutes remaining. Sorry.
Everyone agrees that the Section 5000A penalty shall be assessed and collected in the same manner as taxes. And the party's principal argument why that does not make the Anti-Injunction Act applicable is that, well, that simply goes to the Secretary's activities. And I would simply ask, if you look at Chapters 63 and 64 of the Internal Revenue Code, which are the chapters on assessment and collection, they are not just addressed to the Secretary. There are many provisions in there that are addressed to courts, and indeed talk about this interaction. There are very limited situations in which courts are permitted to restrain the assessment and collection of taxes. There was a statement made that there aren't, and many of the exceptions to the Anti-Injunction Act are in the assessment and collection provisions. There was a statement made that none of these directly confer jurisdiction to restrain the assessment and collection of taxes. That's not true. In footnote 11 of our opening brief, we cite several. I'll simply mention Section 6213 as an example. That says, I quote, "Notwithstanding the provisions of Section 7421A, the making of such assessment or the beginning of such proceeding or levy during the time such prohibition is in force may be enjoined by a proceeding in the proper court, including the tax court. The tax court shall have no jurisdiction to enjoin any action or proceeding or order any refund under this subsection unless a timely petition for redetermination of the deficiency has been filed, and then only in respect of the deficiency that is the subject of such petition."
And all that's going to really what I think Congress's intent was meant to be in sticking the collection thing into Chapter 68. And it's certainly an argument in your favor. The overarching thing in my mind is that it's up to Congress within leeway. And they did not use that word tax. And they did have a couple of exceptions. And it is true that all this language that you quote, in the first two sentences and so forth, it talks about the use of tax in the IRC. It talks about the penalties and liabilities provided by this subchapter. And we look over here, and it's a penalty and liability provided by a different law which says collect it through the subchapter, and it has nothing to do with the IRC. So we've got it in a separate place. We can see pretty clearly what they're trying to do. They couldn't really care very much about interfering with collecting this one. That's all the statutory argument. Now, you followed me. You see what I'm trying to get you to focus on that kind of argument that I've just made.
I mean, I think I'm following you, but the fact that it's not in the particular subchapter for assessable penalties, in my view, makes no difference, because they said it's still clearly, it's assessed and collected in the same manner as a penalty in that subchapter, and those penalties are collected in the same manner as taxes. And so that's, I think, it's rather detailed, but I think it's a rather clear indication that the Anti-Injunction Act applies. The refund statute that does specifically refer to penalties, that has nothing to do with this argument that it's assessed and collected in the same manner as a tax. That would simply go to the point that, well, you can't just call it a tax because they referred to it as a penalty. Finally, on jurisdiction, I think the key point is we have a long line of this Court's decisions that's really been ratified by Congress with all these exceptions in jurisdictional terms. As I read Bowles and John R. Sand and Gravel, the gist of those decisions was not any sort of special rule about appeals. It's that when we have that situation, which I would submit applies as much to the collection of federal taxes as it does to appeals from federal district courts,